This video is the third that looks at concerns relevant to choosing a theory of constitutional interpretation. In this video, the concern we'll be looking at is to do the right thing. We all want to do the right thing, right? Okay, let's at least pretend we all want to do the right thing. In the videos discussing originalism, we discussed the idea that there's a distinction between what one is told to do and what one should do. We shouldn't always do what we're told. We considered a case in which a boss tells an employee to put some merchandise in a car and then report it as missing so that the company can collect the insurance. We saw with this example that there is a distinction between what the boss asked the employee to do and whether the employee should do it. The same distinction, it is argued, applies to interpreting passages in the Constitution. When we read an amendment or an article, the question of what the text is commanding us to do is distinct from the moral question of what we should do. Moral fact theory states that this distinction applies to most of the Constitution. For example, the Constitution states that no person is qualified to be president unless they are at least 35 years of age. Now, is that really the right or best age to choose? Should there be an age limit at all? These are fine questions, but the instructions say 35 years old and that's it. But there are a number of phrases where what you are commanded to do and what you ought to do can't be split apart. These are statements like the command, well, do what you ought to do, in which case doing what one is commanded and doing what one ought to do are necessarily the same thing. There are a lot of commands that take this form. Here's some examples. Play fair. Be nice. Be reasonable. Be good. Show some respect. Do the right thing. The moral fact theory states that there are some passages in the Constitution that take this form, such as the Eighth Amendment. The Eighth Amendment says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. A part of what this says, according to the moral fact theorist, is don't be cruel. This is a command that can only be followed by refusing to do things that are cruel, or specifically, when one refuses to allow punishments that are cruel. The Fourth Amendment, protection against unreasonable searches and seizures, may be interpreted as this type of command as well. It is the command, be reasonable, when conducting searches and seizures. When people follow these types of instructions, they need not choose between following the instructions or doing the right thing. There's no conflict. One follows the instructions by doing the right thing. Moral fact theories are often conceived of as distinct from originalist theories, yet the most widely read defender of a moral rights theory, Ronald Dworkin, considers himself and is considered by others to be a type of originalist. Dworkin asserts that in these types of cases, we obey the Constitution when we do the right thing. The other type of originalist says that we obey the Constitution when we do what the authors of the Constitution would have thought was the right thing. To interpret the Constitution, we need to study history. Dworkin says that we follow the Constitution when we do the right thing. To interpret the Constitution, we need to study moral philosophy. Another argument that claims to show that judges should pay attention to the moral facts springs from the aftermath of World War II. Many of the evils perpetrated during World War II were committed by people who said, I was just following orders. And in fact, they were just following orders. They were applying the law as written. However, this was rejected as a legitimate defense. People can be held morally accountable for obeying unjust orders. The other type of originalism seems to say that the proper procedure is to first determine what the law or the Constitution commands one to do, and then do it. If any injustice or wrong comes from applying the law as written, one can answer, it's not my problem. I was just following orders. In the case of constitutional interpretation, the moral fact theorist is not saying that it's okay to disobey commands when they are unjust. Well, the moral fact theorist might say this, but this isn't what they're talking about in their theory of constitutional interpretation. The moral fact theorist is saying that when the constitutional phrase includes a moral term, one never has to choose between obeying the command and doing what is just, since one is being commanded to do what is just. The point being made here is that it's a mistake to interpret these moral phrases in terms of what the authors believed was just or unjust. If the authors were mistaken about justice, then it can happen that going with what the authors believe would imply perpetuating an injustice. And one can't justify perpetuating an injustice on the grounds that I was just following orders. We avoid this problem by interpreting these moral phrases in terms of what is in fact just or unjust, the moral fact theory, not in terms of what the authors believed was just or unjust, the originalist theory. A third defense of moral fact theory over at least the originalist theory is the fact that the command, thou shalt not appeal to moral principles in determining the correct interpretation of the Constitution, is self-contradictory. The originalist is offering moral guidance as to the morally correct way to interpret the Constitution. As such, it's inconsistent for the originalist to claim that their system is superior because it prohibits appeals to moral principles in interpreting the Constitution. It is a moral principle. If the originalist wishes to argue that judges lack the capacity to make sound moral judgments, and that because of this they shouldn't include these moral judgments in their decisions, then judges, it seems, must also be considered to lack the capacity to judge the merits of originalism. Former Supreme Court Associate Justice Anthony Scalia wrote, quote, "Surely it is obvious that nothing I learned in my law courses at Harvard Law School, none of the experience I acquired practicing the law, qualifies me to decide whether there ought to be, and hence is, a fundamental right to abortion or to assisted suicide." End quote. The moral fact theorist can respond to this by asking whether there was anything in his law courses that qualified him to decide what counts as due process, or unreasonable searches and seizures, or cruel and unusual punishment, or probable cause, or equal protection under the laws and the like. And if not, then perhaps the Harvard Law School ought to change its curriculum. Now, the chief objection to moral fact theory remains that it fails to properly restrict and restrain judges. There are a wide variety of moral beliefs. Moral fact theory seems to invite people committed to different and sometimes incompatible beliefs to use the role as judge to impose those beliefs on the country. In the article Moral Truth and Constitutional Conservatism, published in the Louisiana Law Review in 2021, Gerard V. Bradley argued for the appeal to the moral truth founded in his own branch of religious beliefs. He wrote, quote, "In fact, the contemporary judge can be faithful to the founders only by sometimes relying on moral and metaphysical truths that lie beyond the Constitution. These truths include, crucially, answers to such fundamental questions as when do persons begin? What is a religion? Which propositions about divine matters are answerable by use of unaided human reason?" End quote. An argument against moral fact theory is that it's up to the legislature to reach some sort of political compromise among the different religious and secular communities that make up a society, and then up to the judge to enforce the terms of that compromise. It would subvert the whole process for judges to enter the conflict on one side or the other, and to use the power of judges to subvert the compromises worked out in the legislature. But we must return to an issue discussed earlier. When the Supreme Court declares certain laws unconstitutional, then they are prohibiting the legislature from considering certain options in working out their compromise. And indeed, many of the provisions of the Constitution, the very moral requirements of due process, equal protection, and just compensation, are limits on the terms of any compromise. One main assumption behind moral facts theory is that there are these moral facts. There is something that counts as due process, or just compensation, or cruel punishments, and that thinking people can make some progress in determining what does and does not fit under these descriptions. Now, these assumptions aren't obviously true. However, that's a whole different topic, and not one that we currently have time to discuss.